Welcome back to Mental Breakdown. I'm Minon Maier, and today we are going to tackle the topic of, let's be honest, it usually feels like a big one, divorce. Between all the legal jargon, the emotional toll, and the fear of the unknown, it's easy to feel like you've lost your footing, or maybe you don't even know where to start. I am joined today by the incredible attorney, Laura Chapman. Laura is a partner, managing attorney, and the director of the Modern Law Clinic. She's been in the legal trenches for over 11 years, but what makes her truly a force isn't just her resume, it's her heart. Her passion for family law was born out of her own personal experiences in the court system. She's walked the path, felt the uncertainty, and now spends her life making sure clients never have to feel unheard or powerless. Today, we're bringing in some reinforcements and some conversations to help us find solid ground. Today, we will be covering Arizona Divorce 101, the initial consultation, so what actually happens from the first meeting, what's the roadmap for divorce or the divorce process, accessibility, so some real-time options for individuals with no or low income, the custody confusion, and protecting the kiddos. So let's dive in.
Laura, thank you so much for being with me today. Are you able to give a little bit of your background just for anybody that's listening that might be curious about who you are or what you do?
Yes, I've been practicing family law since 2015. I That's the year that I was licensed, but through law school, I always worked for legal firms, specifically in family law. So I have an additional 3 years prior to obtaining my own license. I've only worked in family law. All of my 12 plus years has been exclusively family law. And the reason that I started in family law was just based on my own personal experience. When I had my first daughter, I was 21 years old and had no idea what to do. So we hired a lawyer who helped navigate the process. And that's the reason that I got into it.
Nice. Well, thank you so much for sharing. And I think it's always great when people have their own lived experience that's connected to their career. I think it just adds a little bit more passion or meaningfulness or insight. So thank you for sharing that.
Yeah, of course.
And this is just for anybody who's listening who might be maybe going through a divorce, maybe thinking about a divorce or separation, or maybe even getting into a relationship or thinking about marriage. So, just kind of information to put out there so people have more information, more knowledge. I really think that having information can be really powerful. So, I'm going to start bugging you with a lot of questions. But my first one is: are there any basic Arizona rules and laws that divorcing couples must follow?
Yes, Arizona is what is considered a community property state. So, what that means is anything that is acquired during the marriage, including assets or debts, are presumed community and then equally divided. If you brought something into the marriage, that can be your sole and separate, but then if you paid on it or put community effort into it during the marriage, the community could have a lien against that sole and separate property. So, we highly recommend prenups, or if you're looking to get married, just talk to somebody. I mean, nobody goes into marriage thinking about divorce, but it's just good to have an idea of what it could be like later on.
So, with the prenup, I don't know a whole lot about it, but from what I understand, is it basically sets out kind of a plan for if there is a divorce of like who gets what, like the just an agreement between both partners so that if there is a divorce, it's already kind of like laid out of what that would look like. Is that correct? Or did I make something up?
No, that's correct. So typically when you're doing a prenup, you each party should obtain their own attorney. You list all your current assets, financial accounts. You can include debts as well. And then you pretty much lay out how you want things to be considered financially, either throughout the marriage or in the event of a dissolution. So you can say that any property we purchase will either be our jointly owned property or it will be whoever purchased it. So yeah, it really kind of makes the dissolution process easier if finances are going to be a concern.
Okay. Well, and I think that's good because we have couples that come into therapy that are doing premarital therapy. And so
Mhm.
that's helpful, I think, for us as therapists to be able to make that recommendation of talk to an attorney, see if a prenup would be something that could be really helpful for you and your situation. We obviously never try to give any sort of legal advice. We just kind of send people in your direction. Or here is a great family law attorney. Here's a great firm. Like, please talk to them. They're the experts. But I don't think a lot of therapists know that prenups are a thing that could be helpful. I think they think of it in a way of like, if somebody has a trust fund or millions of dollars, it's like those are the people that get prenups, not just, like your typical average American that maybe isn't a trust fund baby.
Right, and I mean, it can be for anybody because you never know what your future is going to look like, and so just starting out, let's say you're just starting your career and you go on to be very successful, but something doesn't work out, it's always good to be able to protect yourself or at least have it laid out, like, if you do intend to share everything with your spouse, you can put that in the prenup. There are certain things that are just, statutorily not considered community property, like if one party receives an inheritance that is
Okay.
the sole and separate property of that person. So there are some caveats to it as well.
Okay. Jumping back to the community property piece, are there any exceptions to that? Is there any workaround? Like, if, let's say you're working with a client, and this is all hypothetical for anybody that's listening, I'm making this example up. But, if they don't want to share, like maybe they are a really successful business owner and they don't want to share their business profits, is there any workaround for that? Or is it very much 50-50 with the state of Arizona?
It's very much 50-50. Unless the business had been started before the marriage and then grew during the marriage, then the community just has an interest in it that has to be calculated. But you can do like a workaround with a postnuptial agreement. So
Okay.
if you didn't have something signed before you were married, you could ask your spouse to sign a postnuptial agreement. However, in a situation like that, the other spouse probably would be hesitant to do it. But I mean, we've seen them done, and that's definitely an option.
Okay. So then again, if anybody's listening and maybe is already married without a prenup, maybe consider getting a postnup and we will give referrals and recommendations to family law
Mhm.
attorneys like you. So that's super helpful. I am curious, is there anything that therapists should be doing or not be doing with clients who are going through a divorce or separation other than referring them to your firm?
I guess it depends. If you're treating adults, then there's not a lot other than just doing your job. I always recommend to my clients that they start seeing a therapist during the process, even if they feel like they're doing fine and handling everything okay. You just never know what's going to trigger somebody or what could be going on behind the scenes. And so you just doing your job is very helpful. Obviously, like you said, don't give legal advice, which I don't
No.
think you do. Refer them out to professionals. The biggest thing that we see is when children are involved. If therapists are treating children, then there are things that we would want to look for or maybe inquire from the therapist. So if you are treating children, and there is the potential for a dissolution, then you would want to set the boundaries with your clients. Like, is this going to be safe haven counseling or whether or not you're going to disclose records? There are a lot of therapists in the valley who
Mhm.
refuse to treat during family law processes. And so just making that distinction very clear.
Yeah. For us, that's high risk for a board complaint because
Right.
if one of the parents gets pissed off because, court goes a specific way, and let's say our notes have a court order to be released, it's gonna be a board complaint from the other parent, and nobody wants that. So,
Yeah.
no, but I do think there are a lot of therapists that just stay away from it completely because of that risk. I think there are also therapists that do a really good job screening of, like, "Is this within my scope? Do I feel comfortable treating this?" And then there are some that have no idea what the rules and boundaries are legally of, like, who has sole decision making, who has custody, like, what access does the other parent have access to? Like, do they have access to records and things like that? And so it is messy when kids are involved because there's a lot of different moving pieces. So we appreciate you guys managing that so that we don't.
Yes, and we appreciate the work you do. A lot of times when we first take on a case, the clients kind of treat us like their therapist, and so that's why I always refer them out. That this is not my area of expertise. I can help walk you through this, but you really should be speaking to a professional.
Well, and it's so scary because I'm sure there are other attorneys that don't do that, and they kind of like operate in both roles. Obviously, nobody at your firm, but I've heard horror stories from clients before of like therapists, not therapists, well, maybe therapists, but attorneys that would do similar things or therapists that would try to give legal advice and like,
Mhm.
you need to tell your lawyer this and you need to ask for this, or like the use of chat GPT
Gosh.
to be their source of legal advice. So I think if anybody's listening and they, again, if they're starting a relationship, engaged, getting into a marriage, maybe contemplating separation, divorce, any of that, it is really important to find an attorney that is following all of those ethical and legal principles that the state bar and any other organizations have. And so, just for any clients to do their research. And if they're given referrals, let's say by a therapist, typically we have vetted those attorneys or those law firms because we don't want to give out bad referrals.
Exactly. Yeah. And like you said, it's very important if you're just even contemplating to go speak with somebody, you don't have to retain them. You can just go get more specific knowledge about your specific facts and scenario so that way it can give the client some peace of mind on how they want to approach things, and then talk through it with you, their therapist.
Well, what does that consult look like? Does it cost money? Is it free? How long is it?
So the consultations at our firm are for an hour. They vary in price depending on who you select to have your consultation with. We have newer attorneys who have been practicing for a year or two, and then we also have partners and attorneys who have been practicing for 25 years. So it just
Okay.
varies based on who you select. You contact our team, you can either do it on our website or by calling the firm,
Mhm.
and then you get your schedule. It's typically by Zoom, but we can do in person as well. And then during that hour, you can bring documents, you can email documents if it's over Zoom, and we can really go through all the specific facts and questions that you have related to your specific case. And
Okay.
then at the end, if you decide that you want to retain, we send you a fee agreement. Everything is done electronically now these days, so you don't have to come to the office. Or if you just wanted some information, we take detailed notes, keep them in our system. And so at any time in the future, if you did call back, we would have those notes handy so we could see what we talked about last time.
Okay, perfect. I think that's helpful for anybody who's listening that might be contemplating separation or divorce because we run into a lot of clients where they're like, I don't even know what to do. Like, I don't even know like what my finances are. I don't even know who to reach out to for a family law attorney. I don't know if I should. So we get a lot of clients that
Mhm.
are maybe contemplating but ambivalent or feeling very stuck. And so I think it's helpful just to put it out there that there are options to do a consultation. It doesn't mean that you're retaining a lawyer, it doesn't mean that you're filing paperwork. It's really just gathering information.
Exactly. And we do have options. Sometimes people are worried about their partners finding out about the consultation. So you can have third parties pay, or you can also pay with credit card, cash, like you could stop into the office and pay that way. And we do also offer financing because we know that it is a big chunk of money up front for the retainer. So we it's similar to like care credit, but it's just a third party financing where you can apply and then you're approved or notified immediately. The funds are deposited into their account and then they use those to pay us.
Nice. Okay. I didn't even know that that was a thing. So thank you for sharing that.
Of course.
Are there options for individuals in one income family relationships where maybe the spouse has financial control and the other spouse doesn't have financial freedom to pay for the divorce? I don't know if it's just what you just talked about with like that third party financing or if there are other options out there.
That would be the third party financing. You can also finance it with a community credit card, and then you would just be responsible for it, or it would be equalized in the final division of assets and debts. A lot of people also will reach out to family members or friends if they don't have immediate access, like if it is full financial control where they don't have any access, that's an option as well.
Okay. And so in that case, so let's say it is a client that maybe is not financially secure. Maybe their partner has all of the finances, that they're controlling or they're providing. I am curious, going through the divorce process, are there specific documents or things that then have to be turned over for attorneys to look at or judges to look at that is kind of standard across the board?
Yes. So it's referred to as Rule 49 disclosure. That's just the rule in Arizona family law procedure that outlines all the documents that do need to be disclosed. It is everything financial related, home document, like home purchase documents, mortgage statements, financial accounts, and it outlines all the different items that are required. But long, long story short, yes, both sides are required to do that. A lot of times, if the other party is hesitant to provide those documents, we do have remedies for that. We can file or discovery requests. If they still refuse to comply, we can file a motion to compel or issue subpoenas. So we do have ways to get that information if the other party is not providing it.
Okay. Do people try to hide that? Because I would be so scared of getting in trouble that I would not want to be on a judge's radar at all if I were in that situation.
People try to hide it all the time, or they try to give us snippets of information or a screenshot. We need the full statements from the credit card accounts because if they're going to say that it's community debt, they have to prove that it was a community expense. So they are required to provide all that documentation.
That makes me so anxious just hearing about that because I am a little bit of a rule follower. So I'm like, it makes me anxious for those people that are trying to hide stuff and think that they're going to be smarter than the legal system.
Yeah, it's really surprising because I mean, I'm afraid of that stuff, but these people representing themselves most of the time, but also it does happen when they're represented by counsel. They just really don't care what the judge is going to do.
When there is a one income household, and I guess I'm going to throw a bunch of things out there and I'm hoping it's going to make sense. But if it is a one income household, does spousal maintenance come in for the partner?
So it's automatic, but it is one thing that most attorneys would immediately consider is you haven't been working, the other spouse is. There are 5 factors that would qualify you for an award of spousal maintenance. You just have to qualify for one of 5. And so if somebody has historically been the stay at home parent or stayed at home while the other grew their career, the catch all one is like you're just unable to meet your financial needs. So that is usually the foot in the door for everybody. But then once you qualify, Arizona now has a spousal maintenance worksheet and it
Okay.
works similar to the child support worksheet. So you just put in the information and then it provides a low, mid, and high range amount. And then it also sets a total duration, a minimum duration and maximum. And
Oh,
then you use these additional factors to argue between the low, mid, and high range and then the duration of the spousal maintenance.
okay. And where would people find those worksheets?
They can be found on the Maricopa County website.
Okay.
And if you just go or Google spousal maintenance calculation Maricopa County, you'll be able to find it.
Oh, okay, perfect. That's helpful because, again, as therapists who don't do anything legal, we can also make that recommendation of, "Hey, we know of this resource. You should check it out and consult with an attorney, getting more information for maybe anybody that's contemplating divorce or separation."
Yeah, the Maricopa County website, if you Google Maricopa County self-service forms, it's a great resource for people that want information about what to consider. It has instruction packets on how you could file a petition for dissolution on your own.
Okay.
And it's really a good starting point. And then if you have more specific questions, and then if you do have a lot of assets and debts and need information on how to analyze those or how to go about dividing them, then it would be helpful to have an attorney, and especially to argue the different amounts and durations of spousal maintenance.
Yeah. Well, and I think, I mean, having an attorney, period, is really helpful. Granted, I'm not in your profession, but I'm just thinking, having an expert that can walk you through all the different steps and tell you, here's what's pretty common, here's what Arizona law is, here's what maybe we can try to do, but, it might not be likely. But having that person that can just walk you through it, because I find a lot of clients going back to ChatGPT will use ChatGPT or AI, and then they think that they know everything about how a dissolution works or how like a custody case is going to go. And so we always recommend experts like you guys just to help kind of like hold clients' hands and walk them through it. But I do love that there are some things that clients can do ahead of time to just get prepared for that.
Yeah, and mentioning ChatGPT, we do have a huge influx of clients that will ChatGPT their case and send us information, and it's not always helpful, and most of the time it is not. It is a great resource if you have questions on your own, but we it's very difficult when clients bring us stuff because ChatGPT is not a lawyer. They do hallucinate cases, they make stuff up, and it is discoverable information as well. So if you put information into ChatGPT and opposing counsel subpoenas it, they could get private information that you might not necessarily want to share. So always be careful with what you put into ChatGPT during a divorce.
Yeah, I didn't even think about the discoverable part because I guess opposing counsel could really ask for anything and everything if it's connected or makes sense.
Yeah, they can ask for anything as long as it's relevant to the case. So if they send a discovery request, you do have the ability to object to it. But
Okay.
if the court determines that it is relevant to the litigation, they can let them proceed with their request.
We've come so far. I mean, ChatGPT was not a thing when I was in grad school, and now it's like coming up it with family law. I mean, we even have clients coming in saying ChatGPT diagnosed me with this thing. And sometimes it's right, but a lot of times it's like, well, let's explore that, right? Because there are so many
Mhm.
different nuances in between. Like, is it this diagnosis or this other diagnosis? Because a lot look the same. And I love that you're saying ChatGPT will make things up. They'll hallucinate things, they'll create maybe fake cases or different things like that. So, like, it can be a resource, but don't take it as fact. That's where I
Exactly.
talking to the professionals is going to be more helpful and also protect them with it.
Exactly. And there's only so much that you can type. I feel like a lot of people will summarize when they're like typing into a
Mhm.
search engine like that, that you don't get all the information that you would get asking the client direct questions. And same thing for us.
Yeah. We've come a long way with AI and in the time that I've been practicing therapy. So it's interesting to me. I'm interested to see what will happen with it as more AI models come out. And not that we have to continue that conversation on this podcast, but it'll be interesting to see what happens with that.
Yeah, for sure.
Are there important things that providers need to know? So, like therapists that need to know about custody? Because I know you talked about like a safe haven or different things like that. So, are there things that we should be aware of with regards to custody arrangements or decision making power or anything like that that maybe people listening to the podcast aren't aware of, whether they're potential clients or therapist or any other provider that might be involved?
Yes. So if the parties are already divorced as a provider, it's considered a medical decision. So you would need to see what the orders are for legal decision making. If it's joint, then you need both parents' permission in order to treat the child. But if there are no orders, like let's say they're talking about divorce or they're in the process, but there aren't any decision or any orders for legal decision making, then you're kind of operating in like a gray area where you don't necessarily need both parents' permission or whatever your guidelines are for that. But as far as the family court is concerned, either party could sign the child or children up for therapy at that point. Um,
Okay.
and again, that would be based on whatever your process is for intake, if you typically need both parents or just one if there are no orders.
Okay. But it sounds like if somebody, let's say, has physical custody, that doesn't mean that they have sole decision making, like sole custody, medical decision making. Am I understanding that
Correct.
correctly? Okay.
Yeah.
Okay.
So
Go ahead.
in Arizona, custody is now like an antiquated term. A lot of people still use it, even judges still use it. But now it's considered parenting time and legal decision making. So it's very unlikely for one parent to have primary parenting time, like most of the parenting time, and then not have any legal decision making. Usually in Arizona, it's joint legal decision making. In extreme cases, it's sole to one parent. But then there is also the third provision where joint legal decision making, but one parent has final say. So in that instance, let's say somebody comes to you and mom has joint legal decision making, but she has final say. You could accept the children or child as a patient without dad's consent.
I'm just thinking because we've had situations where, there is joint decision making. I hope I'm using that term right. And so, one parent is all about therapy and another parent is, for whatever reason, against it, whether they're just mad at the whole process that they're getting divorced or they really don't believe in therapy. So, is there something then that the other parent could maybe petition for or ask for so that they could get that like final say or final decision making or even some like, I don't know, like a court order that kids should be in therapy or need to be in therapy?
Yeah, so if that would be a situation, depending on what process or what point in the process they're at. If there's not any pending litigation, they
Mhm.
could use that to modify legal decision making and have the parent that wants therapy be awarded final say. You do have to show why it's in the children's best interest and how fathers, in this, if it was mother and then father objecting, that father's decision was contrary to the child's best interest. Um, if the process was ongoing, you could also file a motion for temporary orders to have one parent awarded final say.
Okay. Do you ever see situations where, and I'm just thinking, in Arizona, regardless of custody, both parents have access to the clinical information or medical chart. And I don't remember which rule or statute that is, but it is something that's ingrained in our kind of profession of like, if you are working with kids and there is a divorce, you have to be really mindful of what you put on the chart because both parents can see it. And so I am wondering on that note, is there a way then to maybe remove access for one of the parents? Like I'm thinking if one parent was maybe abusive or toxic or anything like that. Is there a way to protect the record in that way?
I don't believe so. I think the access to medical records is regardless of legal decision making. I think it's only able to be protected if the parents' rights have been severed.
Oh, okay. And is that a common thing in Arizona that parents' rights get severed?
No, it's extremely difficult. That's more juvenile law, so I don't practice that. I know it seems like juvenile and family are very close related, but they are very different. But it is very difficult to get a parent's rights severed. The statute, I believe, says 6 months of no contact, but even at that, judges usually require at least a year and then multiple other factors for that to go through.
Okay. Well, I had a friend who was trying to get parental rights severed. This was a long time ago, but the partner was basically in prison testing positive for drugs. And I think it took my friend 8 years to get the parental rights severed.
Yeah, the juvenile court does give the other parent a lot of chances. That's not surprising to me at all. It seems like it would be pretty straightforward, like in prison, still testing positive, clearly no relationship with the child.
Right.
Yeah.
When I heard that, I was like, wow, like that is just shocking to me. And obviously, this was, earlier in my career. So I didn't know a whole lot about like the little bit that I know about family law or the process or resources, but it was just very shocking to me. So I think it's important for clients or potential clients or people that are listening to understand that it's not like you're just going to ask for a parental, like you can't sever parental rights and it's going to be granted that day or in that next court hearing. There has to be a lot of I guess, like proof and evidence to show why it should happen. And even then, you might have to keep showing it or show more, is what I'm hearing.
Yes, absolutely. And kind of along those lines, when people are going through a dissolution, if this is just kind of the traditional family setup, but if mom had been stay-at-home parent, dad worked, now we're trying to figure out a schedule to share the kids, a lot of times the mom will say, well, I did all their appointments, they were with me all the time, I should be the primary parent. In Arizona, the judges kind of start with a baseline of equal parenting time, joint legal decision making, regardless of how it was set up during the marriage, because the judge understands that you structured your family this way because you were a unit together.
Mhm.
Now that you're separated, that other parent shouldn't necessarily have less access to them. So that's a very common theme that we see in consultations is kind of explaining the dynamics of a parenting time schedule and then also factors that kind of would lean for a judge giving more parenting time to one over the other. And typically it's all logistics based on the locations of the parties, their work schedule, things like that. It's not how your family was set up before, it's how it can operate independently now.
Okay, that's helpful to know. If there's something like, let's say, an abuse allegation that's coming up through the court process, through, the divorce process, is there anything that the family should be doing to maybe show that there's an abuse allegation or even that abuse occurred in terms of like therapy, documentation, anything like that that would be helpful?
Yes. So any notes that you take would be super helpful. A lot of times there will I've reviewed therapy notes in situations like this and they're very vague. Sometimes it's small children and so it's really hard to probably document anything like that, but what would be helpful from my perspective is if you could put in your notes what your thoughts are based on the observations because a lot of times we'll get notes and I don't know if it's the therapist just thinking that it's common knowledge or like they'll write that the child did this. And so we're like, okay, well, what does that mean to you? Like, how do we interpret that? Because sometimes we'll get the notes, but the therapist will not testify. So then we have to connect the dots with that. But I also understand what you just said about one parent having access to the records. So sometimes you do want to keep them vague.
Yeah. And we don't want to testify.
Right.
And if I mean, there are some that I think do like forensic therapy or, really specialize in court involved families that maybe are more comfortable. But for, therapists that just work with like trauma or, relationships or things like that, like we don't want to be at court at all because it puts us in a position where are we an expert witness? Are we a factual witness? What is this going to do to the client? What does this do to the relationship? So we try really hard to avoid that piece of it.
Yeah, absolutely. I do, from my perspective, I also try to do the same. If there's an issue where a child is afraid of the other parent or we're trying to reunify them, I always recommend two separate therapists. One for just the child that he or she feels safe with, and then a second one that can maybe give us reports on how the reunification is going, how the repairing the relationship is going. So
Yeah.
that way we can take something to the judge to say, this is where we're at. We don't think the time should increase, or vice versa. Like the therapy is going well. Dad needs more time with the child.
Yeah. And from our perspective, we would make the same recommendation. And I would hope an ethical therapist would make the same recommendation because we shouldn't be treating multiple systems that are,
Hmm.
you know what I mean? Like the kiddo and then maybe like kiddo and like parent who's getting reunified because it creates a conflict of interest. And then what if we share something in the reunification session that was in the individual session with the kid and now it's a whole problem? So hopefully therapists would make that recommendation too, and also making sure that we're working within our scope so we're not doing like a reunification situation where we have no training in it or we don't know how to document it or we don't know what the steps are, we don't know what court's looking for. So I think
Hmm.
we give out those referrals to those places that specialize in either high conflict, court involved, forensics, different things, just because, again, it's outside of our scope, at least for my practice.
Yeah. And it is very hard to find those too. And I think for the reasons you said, like nobody wants to testify in court. They don't want the reporting to the bar or to the board.
Yeah.
Um,
Yeah. And we don't want to piss off the other parent. It's like we just want everything to be like calm and good and everybody's happy and like it's fine. But I also know that in like a family law situation, there probably isn't just the happiness and it's calm because usually they're getting divorced for a reason. So
right.
so if there is abuse, and let's say because of the access to the records piece, Would it be, I guess I'm just curious, like, how we could document it in a way that would be protecting our, you know, license to practice, protecting the kid if the other parent gets access to it, but then is also connecting the dots for you guys based on what's being reported to us. Is there anything that would be helpful in that sense?
That's tricky because, I mean, the thing that would be most helpful is putting it in writing somehow, which I know is probably not what you want to do, but the judge will only take so much testimony without any evidence backing it up. And the judge then has to determine the credibility of the testimony. So if you have a conversation with one of the parents about how the child is expressing this, or you believe the child is truthful when they're telling you this, you tell that to the parent, they tell that to us, we take that to the judge.
Yeah.
There's not anything that specifically confirms that unless we have something from you.
Okay.
So it's really difficult. I mean, hearsay is allowed in family law unless somebody invokes the rule, which they typically don't.
Okay.
But the judges hear he said, she said stuff all the time. Unfortunately, it's a big game for some parents to say, well, they're abusing the child. No, I'm not. You're abusing the child. Like it just, and so then the judge just has to, okay, who's more credible in this situation? And if they both look credible, okay, I don't really have anything. And so a
Yeah.
lot of times their hands are tied unless there's more documentation or something that you could put in writing. It doesn't even have to be full therapy notes. It could be just a letter saying, I don't want to divulge what's in our sessions, but this is what I'm seeing. That
Mhm.
could be, I don't know if that's something that you would be willing to do.
So we, at least my practice, does a like factual summary of services. So we always try to give that if there's a records request instead of every single progress note or interaction. And we tell clients, we write this from a clinical lens. We're not writing this from a legal lens. And so there is a chance that, like your ex's attorney could read this and create a different narrative than what we're trying to put in the progress notes. And so we do try to do that summary. And typically, with the summary that we do, at least in my practice, is it's when did treatment start? How many sessions have they done? What are diagnoses that are current? What's their prognosis and treatment? And then I think also, do we have recommendations for ongoing therapy or, different things like that, or even risk factors? So if we have a kid that maybe has, I don't know, let's say they cut themselves. Obviously we would be documenting that those in the progress notes. We would have a safety plan. We would notify parents, but we would also put it in that factual summary of services, but maybe not to the detail that would be in the progress notes. And sometimes that's a good way for us to say, here's that information without opening up their whole file and chart.
Yeah, that would be very helpful. Unfortunately, in the legal field, the other party would probably subpoena all the other stuff
Yeah.
just to try to pick it apart.
Yeah, and I think for us as therapists, I don't think we have to respond. We can deny subpoenas, and I don't know all the legalities around it. So that's typically why we have our own like professional lawyer that's specializes in mental health and therapist. But if it's that signed court order from the judge, we have to do it, and there's no
Mhm.
workaround for us in that sense.
Yeah, so I have run into that before where we did try to subpoena and they said that they could not release unless both parents signed
Mhm.
a release of information. And so sometimes we will take it to the judge. Other times we're like, okay, we'll try to get it some other way or try to use this evidence instead.
Well, the court order protects us to some degree because, we're then breaching confidentiality. So if we have a court order or both parents have consented, it's like that gives us a layer of protection. So we're not going to get a board complaint about you broke confidentiality. And so as
Mhm.
therapist, one, we would rather not have any of this that we have to do. But if we are working with a kid or a couple where there is divorce, that court order is much more helpful than the subpoena.
Right. Yeah. I've worked with therapists in the past where they're like, they will talk to me, have a conversation, but they're like, I can't release, just go get a subpoena or something and I'll give you what you need. And I think a lot of people don't know that like it can be easy to get the information. But then again, I also have these discussions with my clients. Is it worth it? Do you want to break the trust that your child has established and potentially have them not trust the therapist if we're using them in court? So, I mean, all kinds of things to consider. And I think every case is very different too. So we're throwing like a bunch of different scenarios out,
Yeah.
but the advice that I would give would be different for every single case
Yeah.
just based on what the client's wishes are, what's going on with the child, how we want to progress things, stuff like that. So every case would be different.
Yeah. Well, and same for us too, because, if we have two parents that are amicably deciding to separate, that's very different for us than if, one parent left suddenly and is claiming all these abuse allegations, and then the other parents, allegedly saying that there's abuse allegations and things like that. Like, that's where it is messier for us. And so, same thing, like the way that we would go about the case, the way that we would interact, the way that we would document. I mean, we would have probably a lot of consultations about how should we be documenting this to protect ourselves and the kiddo and the family. But that's all
Mhm.
those like little nuances that I think some people just don't think about when they're thinking about, you know, what the divorce process is going to look like, or what am I allowed to bring into it? What can I ask for? So I am glad that we're having this conversation today, and hopefully it's giving people some information if they're looking for it.
Absolutely. And just the importance of being upfront about what your goals are too. Like if you are looking for a therapist for your child, like, is this for court? Is it you just want to get them in because you have like immediate concerns, things like that? Then you can map it out how you want it to go, if it's something that you can provide, or if you refer it out, or like we talked about before, have different counselors. So, like this is for just this, and this would be for something you could use for court.
Yeah. And we've had potential clients call in that say, we're going through a divorce process. I want my kids in therapy. And we always say we need both consent. And we have a policy of neutrality. So whatever we're sharing with one parent, we're sharing with the other one, unless there is a significant risk factor that would put somebody in danger. And so we stand really firm on that, which means we've lost a few clients because they don't want to involve the ex. They don't think we should have to do that. They tell us a story that may or may not be true, but it's like that's too risky for us and the kids because yes, we could start with them, but if the other parent says, I don't consent to therapy, you have to stop seeing them, then we just abandon the client at that point. And so we try really hard to just not enter into that unless we have both consents from both parents, whether they're married, never married, divorced, separated, just as a way to protect the kiddo. Yeah. Okay. So, one last question. Is there an age that the court starts paying attention to specifically what the child wants with regards to custody? I know that's not the term that's always used anymore, but like custody or parenting time, decision making, anything like that.
Well, in the factors for legal decision making and parenting time, it's ARS 25 403. One of the factors of like 11 to 14 ish is the child's wishes
Okay.
over her age to express their wishes. So it is considered, but it's one of several factors. And times the court will order child interviews. Typically, in my experience, I haven't seen a judge do it under 10 years old. Even right around 10, they're a little hesitant too. But
Okay.
certainly when they're a teenager and older, they do start to consider what the child has to say or what their wishes are.
Hmm.
Um,
That's
There
helpful.
are, like I said, there are child interviews that you can ask for, and those can be confidential or non-confidential, so it does really give the child a chance to express their wishes without it being disseminated to either parent.
Okay. And would they have to ask for it to be confidential?
Yes, unfortunately, the parties do have to agree for it to be confidential, otherwise it's non-confidential, and then a report is generated, and both parties get, like, a copy of what was discussed.
Okay. Well, that's interesting because I think that is a question we get from couples that maybe are divorcing of, well, don't my kids have a say in this? And so again, we would refer them to a family law attorney, but being able to say like, what we've heard, and this isn't legal advice, definitely talk to an attorney, but around teenagers, they will listen to it, but that doesn't mean that that's going to be given, kind of what I'm hearing. So the judge will hear it, but it might not change the outcome depending on the situation.
Yes, that's correct. I've had situations very recently where a 17-year-old didn't want to go to parenting time with her dad anymore. Dad filed a petition to enforce it, so we asked for a child interview. The court said that they weren't going to change parenting time, but they also weren't going to find mom in contempt for not complying because the child was at an age where she chose that she didn't want to go. And you can't make a 17-year-old do something like it. What are you going to do? Drag her to the car? So, uh, again, every situation is different. Um, but the child interview was very telling for the judge where he's like, She's almost 18. I'm not gonna disrupt anything. There's
Yeah.
no reason to change the parenting time." But in a situation where the child's younger or like 15, 16, the judges do definitely consider that because, again, it's you can put a 7-year-old in the car and say, "We're going to dad's house." You
Yeah.
can't put a 16, 17-year-old in the car and say, "We're going to dad's," and prevent them from not leaving or driving away if they have their own car.
Yeah. We've had situations where that's happened, where a kid's refused, and then the other parent will call the cops to the house of the kid. And then we do a lot of trauma therapy on that because it's just so traumatic. And it's like, that's not going to help them want to be at your house anymore. And it's usually in a situation where they are big enough where you can't physically like put them in the car or anything like that. And so we've had a couple of those over the past probably I would say 10 to 15 years that we do a lot of trauma therapy on that afterwards.
Yeah, I bet that, and the way that the police handle it sometimes is not so great, in my opinion, which I'm assuming is what leads to the trauma therapy that is needed, but cops in Maricopa County seem to treat it a little bit differently than, like, Pinal County.
Mm,
Maricopa, I've heard that any of the city police officers just say, "It's a family dispute, go back to family court,
yeah.
figure it out with enforcement." Cops in Pinal recently in cases that I've had, they're threatening the children, saying that they're gonna send them to juvie and that this is gonna go against their record. And so they're scaring these children that are
Jeez.
already scared to go to the parents' house. And so, I mean, even just based on what county you're in, you can have a different outcome with situations like that.
Can kids go to juvenile detention for not going? Is that a thing?
I don't think so. I think I'm just getting like secondhand information, but
Okay.
yeah, I don't think so. They reference some statute. Typically, it's custodial interference that is could be charged against the parent. I've never heard of a police officer saying to a child, "This is going to affect your record," because I don't know how it could. Like procedurally, I
Yeah.
so yeah. But just more confusion for us in
Yeah.
family court to try to figure out how to navigate that.
Well, and I don't like the bullying and the threatening, so that bothers me, but I don't
Yeah.
know if I'm gonna do anything about that or can do anything about that. But again, working with a client where that's being reported, we will then make that recommendation of like, you should talk to your attorney, or if you don't have one, here are some great people that you can talk to. And so we always just try to push people in the right direction so that they can get what they need.
And in this specific instance, we are trying to get the kids in counseling for situations like
Yeah.
this that have come across, and they have joint legal decision making, and dad won't agree to it. So it's, yeah, our job is never ending to
Yeah.
try to fight against this stuff.
I'm so glad you guys do that and we don't have to do that because you just want to work on emotions and feelings and trauma and communication and not all of that stuff because that sounds overwhelming to me in my therapist brain.
Well, I could never handle all the emotional, the second. Oh my gosh. I would not be able to handle all the emotional stuff with the clients all day, every day. I get a little bit of it when they try to treat me as their therapist, and I happily refer them out. I applaud you and for what you do.
Well, and same. I think there's this mutual respect between, I mean, obviously you and I, but also between the professions because there are times where we are working closely together depending on the situation. And so being able to have good referrals, people that are in alignment with the way that you practice, even if it's a different profession, I just think is so helpful, not only for the
Mhm.
professional, but for the clients, for the kids, for anybody involved.
Yes, absolutely.
Yeah. Well, thank you so much for joining me today. I think this is really good information. I'm sure people are going to have a lot more questions based on what we talked about. I mean, even though every situation is a little bit different. So I might be reaching out to you in the future to do another one. And hopefully you will say yes.
Yes, absolutely. I would be happy, like, if people had other questions and you had just, like, a Q&A with questions you could, I would be happy to do that.
Oh, I love that. So if anybody's listening and has questions, send them to us and we can then plan that later. But I do really appreciate you joining me today. Thank you so much.
Thank you, Manon.
Welcome back to Mental Breakdown. I'm Minon Maier, and today we are going to tackle the topic of, let's be honest, it usually feels like a big one, divorce. Between all the legal jargon, the emotional toll, and the fear of the unknown, it's easy to feel like you've lost your footing, or maybe you don't even know where to start. I am joined today by the incredible attorney Laura Chapman. Laura is a partner, managing attorney, and the director of the Modern Law Clinic. She's been in the legal trenches for over 11 years, but what makes her truly a force isn't just her resume, it's her heart. Her passion for family law was born out of her own personal experiences in the court system. She's walked the path, felt the uncertainty, and now spends her life making sure clients never have to feel unheard or powerless. Today, we're bringing in some reinforcements and some conversations to help us find solid ground. Today, we will be covering Arizona Divorce 101, the initial consultation, so what actually happens from the first meeting, what's the roadmap for divorce or the divorce process, accessibility, so some real-time options for individuals with no or low income, the custody confusion, and protecting the kiddos. So let's dive in.